SRIRAM's IAS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello students, welcome to SRIRAM's IAS. Welcome to this current affair class of polity. And this will be our 9th class. We have made 9th current affairs classes which are important for your upcoming prelims examination of 2025 on 25th of May. Let's see what is there in this important slide. So, obscenity law. Now, everybody knows about this controversy which has happened, that Ranveer Allahabadia, this person, now he is in the limelight for a very negative thing which has happened. But before that, he was a YouTuber having his own channels with millions of subscribers on it. He was a podcaster, he was a health coach, and now he is in the controversy because of saying something which is considered obscene in the language of law, which the society has not accepted very positively in India. And this is Samay Raina. So Samay Raina runs a comedy show. He's a comedian, and Ranveer Allahabadia was a guest on his show. And during that time, during the airing of that particular show, this thing has happened. Now, because of the coming of the internet and because of the coming of YouTube and digital media, the obscenity and other things can be transmitted very easily to large number of public. Earlier, it used to be books and stories. For example, Manto was one of the writers who used to write. He always used to write such a thing where he would push the limits of the society, writing things about women and their sexuality in such a way that the present society at that point in time would not accept it. But he wrote so as to push the limits of the society and its thinking. And the obscenity, it's a concept which changes over time. For example, what was obscene in 1920s and 30s was not obscene in 1970s. And what was obscene in 1980s is not obscene now. With the coming of internet and the widespread globalization, the Western media coming into our country, the boundaries has widened a lot. But still, the Indian culture holds its root very deep, and what you should speak on such platforms such as this platform, which is seen by millions of the viewers, you should be very conscious of what you speak, because it affects the hearts and the minds of the young people in millions. Because if they consider you as a celebrity, if they consider you as their role models, and you speak like that, it gives a very wrong impression to the public, very wrong impression especially to the young mind. And speaking obscenity, which can also affect the adults, turning them into a negative zone of sexuality, is not considered appropriate socially and according to law. So now, coming to the controversy, India's judiciary is no stranger to hearing cases about works or actions of public figure being labeled obscene. Now, this is a controversy also. Sometimes it is also seen that politics and courts also have been criticized to undermine the freedom of speech by using the word obscene too strictly. But also courts have came up, and such as the one example we will see where the courts forms a great and a beautiful distinction between usage of foul language and at the same time obscene material. And they said that both must not be considered as same. What is obscene is not necessarily the foul language which are sometimes used in movies and web series. That is different. A community standard is applied to it. Sometimes you see out there in the community, people speak it out of frustration, out of anger, and also sometimes when they are talking to their friends out of happiness and in jokes. That cannot be considered as obscenity, but there are several tests to it, and let's see what is there in this slide. So the context is what I have told you. Ranveer Allahabadia, founder of the YouTube channel Beer Biceps, has become the center of controversy. Okay, because he made he was a guest appearance, giving a guest appearance to the show India got latent. Here he has spoken several things which was considered as obscenity, and multiple FIR has been filed against him. The Assam police has filed, the Mumbai police has filed, and he has moved to Supreme Court under Article 32, which is the right extended to all the citizens, a remedy where if your fundamental rights are infringed, you can directly approach the Supreme Court. Supreme Court, although has given him interim bail, but at the same time has said several strong words against him. The court have said that there is something dirty in this person's mind that has been spread through this program. The words you have chosen will make parents ashamed, sisters ashamed, and the entire society ashamed. Now, these are very strong words said by the Supreme Court. Usually, courts don't say these things, but yeah, at times courts have to be very, harsh in order to bring order to the society. Okay, so obscenity, according to the Oxford Dictionary, defines as offensive or disgusting by accepted standards of morality and decency. So this is a very simple definition of obscenity. If you see on the internet and you search this word obscenity, you will find different definitions. Now, what is obscenity and the meaning of obscenity according to law, we are going to see. So the legal basis of this is two important sections of Bharatiya Nyaya Samhita. The erstwhile Indian Penal Code also had this particular section. Now, Bharatiya Nyaya Samhita, this section is 294, and the Information Technology IT Act of 2000 section is 67. I hope you remember this particular act, and section 66A, which was scrapped by the Supreme Court, calling it unconstitutional. But 67 is still there, and according to section 67, it criminalizes publishing or transmitting obscene content online. Now, think about it. If you have seen obscene content, or if you have the possession of obscene content, what you can do? You can display it somewhere, okay? Or you can transmit it to your friends or to anybody you like, or you can sell it. You can, exchange of money. You can actually sell that material. Now, all these things, they're not allowed according to law. You cannot display the obscene material, you cannot transmit the obscene material, and you cannot sell that obscene material in the open market. That's prohibited according to section 249 of Bharatiya Nyaya Samhita. Now, let's read what's written. It punishes those who sell, import, export, advertise, or profit from obscene materials, such as books, paintings, and figures. Now, obscene material, there can be books which can have stories which can be obscene. Some of the books by Manto, there was a movie also made on Manto. He went to Pakistan after independence and lived there, never enjoyed. He was a writer here in Mumbai. He was writing in Mumbai before independence, and after the partition moved to Pakistan. But his books, you see, many of the stories written by Manto were considered obscene. Paintings, there can be paintings which can arouse negative sexual feelings in a person, can have deep impact on the society, especially the younger minds. So paintings can also come in that category and can be considered as obscene. Figures, sculptures, whatnot, can also be obscene. And coming of the digital age, the digital media, the imagery, the visual effects, it has far greater impact than all these material, because it's easily absorbable by your eyes, by your senses. And that is the reason the courts, the law, the society are more vigilant towards circulation of obscene material through electronic media, material especially which is visual, which has visual effect, and that thing has more greater impact on the psyche of the human being, on the mind of the human being, than the books and the paintings and the figures. and also includes display of any content in the electronic form. Okay, in the electronic form. So when there was no electronic form, there was no phones, when there was no internet, during that time, books, paintings and figures were the medium to show sort of, to display the art and the architecture of a human being and to display the creativity of the human being. But with the coming of electronic media, now it can be done through many mediums, you all know that. It describes such material as that which is lascivious, appeals to the prurient interest. It simply means material which is overtly and excessively sexual. Material which is overtly and excessively sexual, or which would tend to deprave and corrupt persons who are likely to read, see or hear matter contained or embodied in it. Now, what is the punishment for all that? Up to 2 years of imprisonment, 2 saal ki jail, with a fine of 5,000 rupees for the first time offender. If you are a first time offender, this is what you can face: 2 years of imprisonment along with 5,000 rupees of fine. Or and, so there's a and here, not or. There is no or but and. That simply means you will be fined and at the same time you will be sent to jail also. Both the things at the same place. And this is for the first time offender. If you are the second time or the third time offender, the punishment is going to be far more tougher and far more grave. Information Technology Act, it also criminalizes publishing and transmitting of the obscene material online. Strict penalties up to 3 years of imprisonment and a fine of 5 lakh. This is a great huge penalty here. 5 lakh for the first time offenses. So this is the legal basis of obscenity in India. Now how this particular thing has evolved over a period of time, we will see evolution of obscenity laws. So there was this one test which was applied. It was a case in 1868 in UK. It's called as the Hicklin's test. It derived from Queen versus Hicklin. This was a case of 1868 in England, in UK, applied in Ranjit Udeshi versus State of Maharashtra. So in 1964, the court have taken inspiration from this case and applied the Hicklin's case in the case of obscenity which was there in the courts in India. Okay, to ban Lady Chatterley's lover. This is one art material which was considered obscene, and the basis of considering it obscene was this Hicklin test, which was used by the courts as a source to ban this material. Then, you know, what does it say? If you see it, if any part of the work corrupts susceptible minds, it is obscene. That simply means any paragraph, any dialogue, any scene which is written in the book, anything in a material, if in some or the other way depraves the mind of the young people, depraves the mind of the adults, or deprives, you know, in a work that corrupts the mind of the people, it can be considered as obscene. Now, it is important to understand that the whole book may have been written on a topic and there is nothing obscene in that particular material, but only one small part of it is obscene. Then that material can be declared or as obscene material, or can be banned also. This was the Hicklin's test, and it was a very tough test to be applied to any material, because let's say if there is a movie or there's a script written and the movie runs for about 2 hours and there is this one scene in it, 30 seconds. So instead of cutting down that scene, if you just declare the whole material as obscene, it's of no use. It's sort of infringement or curtailment of the right of freedom of expression. Okay, so this test does not stand for too long. It was although applied in India, but in 2014, in Avik Sarkar versus State of West Bengal, in 2014, Supreme Court ruled that the national contemporary modes and contexts must be considered. The important thing is it rejected the Hicklin's test. The Supreme Court in 2014 rejected the Hicklin's test in favor of modern societal norms. Modern societal norm simply means that with the changing society, this was the case of 1868. It was, society some more than 100 years back. So, with the evolving society, the definition of obscenity is also evolving. What was considered obscenity that time may not be considered obscenity now. So, to apply the test of obscenity, which was prevalent or which was used during that time and has been used for many decades, is not necessarily logical now. It is not reasonable to be used now. So, we have to evolve our own mechanism to see what kind of tests must be there in order to declare a material as obscene. Should we see the whole material as obscene, or should we see the part of it and declare the whole material as obscene? Now, this was the debate going on in India. Okay, for example, there are sections of society in India which consider a particular thing as obscene, but the same thing is not considered obscene by some other section of the society. So the courts and the law has to come up with some definition, some standard, or has to take it case by case basis in order to evolve some kind of mechanism to prove a material to be obscene material, or else giving a one size fits all definition to obscenity may not work in today's society, where there is too much of digital media prevailing, where there is a great consciousness about the rights of freedom, especially the speech and expression and profession. Some other test was also there in USA in 1957. They have used something called the Community Standard Test. Okay, and in 1959, Obscene Publication Act, this was again in UK, ruled that the material must be judged as a whole. Now, see, this also happened in UK. This also happened in UK. So, about after 100 years, UK have came to this conclusion that Hicklin's test does not work. Okay, because it used to see only a part of the work, not the whole work, and declared it obscene. But in 1959, the same UK courts have said that the material must be judged as a whole. Okay, if a book is written about a motivator, or if a book is written about a saint, and there is one paragraph or one page which shows obscenity, then that particular page must be removed or should be banned, not the whole book. In the Hicklin's test, the whole book was declared as obscene, but such was not the case in the 1959 Act, Obscene Publication Act, where the whole material was judged at the same time. I mean, like, it was seen at the same time. The whole material was judged that a particular book is written about a motivator or a saint, and the whole work has nothing to do with that one obscene paragraph or one obscene page which is there. So this is surely a step towards greater freedom and in-depth understanding of what obscenity can be in an artistic work. Now, the community standard which needs to be applied, which was applied in the case of Roth versus United States in 1957. This is also a very good standard. It was although applied in one of the cases in India also. We will see this in the college romance case in 2024. So in college romance case, Supreme Court has came up with a very good definition that foul language and the usage of foul language in web series and in movies may not necessarily be considered as obscenity. Obscenity is different from foul language. If you see, foul language is used everywhere. Even in the group of friends, they use foul languages, not taking it to heart. Okay. Sometimes foul languages is reflected in plays, in dramas, in books, even in online shows, everywhere. But people do not take it something, which can deprive the mind or which can affect the mind, the susceptible minds, or that must not be considered as obscenity. Obscenity is something else. Obscenity, in the words of Supreme Court, which has said that it ashames the society, it ashames the fathers, it ashames the sisters. So, speaking in foul language, nowadays it has become a part of languages and cannot be considered as obscenity. This is something we have to judge. That is what is called the application of the community standards. Okay, application of the community standard, that the particular community, it can be community in India, can be community. See, the community at villages in India and the community at third tier city or second tier city versus the community in metropolitans, all are different. What can be considered in many, I'm very much sure you must all have heard about these stand-up comedies, and too much foul language is used in those comedies, and sisters, brothers, fathers, mothers, everybody go and see those, and they do not feel anything negative about it. They all laugh at that language and the jokes which are cut in those by these comedians, the stand-up comedians. Everywhere in Delhi, NCR, especially if you see in Gurgaon and Noida, these shows are happening. So, Supreme Court has clearly demarked the differences between what obscenity is and what foul language is by applying the community standard. So, community standard must be applied. A scene, if it is considered by someone in a movie or in a web series or in a book or in a painting, if a particular piece of art is considered as obscene, and if the person reaches the court applies this community standard principle, that does it have larger impact on the community, or does the community sees it as obscene or not? If the community has no problem with it, then it's okay, then it's not obscene. But if the community has a problem with it, if it is going to affect the community in the negative manner, then it can be considered obscene. So there is a new test, the evolution of new test, community standard test, which is now used in India. It was used in the college romance case in 2024, where the vulgar language should not be considered as obscenity, okay, unless it arouses sexual or lustful thoughts. Both things are very much different. I hope you have understood. And this recent Ranveer Allahabadiya controversy, allegations of obscene remarks led to legal scrutiny under BNS and IT Act, and the Supreme Court's words are quite strong here. It said that words chosen would make parents and society ashamed, and the case raises debate on stricter online regulation versus refining existing law. Now the challenges of obscenity are these. There are blurry lines. What is offensive versus what is truly obscene? We have seen already. Offensive language, vulgar language, those are one thing, and obscenity, this is something else. If let's say in a web series, a character speaks very offensive language because the character in a movie or character in a web series has been shown as a person who hates one community, and these are how stories are made. You know, you will have a character, you will have another character in the story, and this is how society is reflected in the movies and in the stories. So there are characters, and one person can be very hateful towards another community. Now, how to reflect his hate in that particular movie or in that particular web series? That can be done by the speech he made, the actions he takes against that particular community. This is how it is reflected. So it can be very offensive to that community. But now it is understood that it's just a movie. Okay. So there has to be some difference between what is offensive and what is truly obscene. Truly obscene is something you will not like when you see it. Offensive at one point can be called as the necessity of the story, that it is important to reflect the true nature of the character which is built in the story. But obscenity, not necessarily. A movie cannot reflect the true nature of a person by obscenity. There are other ways of doing it. This is not the only way. But yes, offensive language, vulgar language, it can show the nature of a character. But obscenity is not allowed. Enforcement issues. Hard to regulate content on digital platforms. So much content is created nowadays on digital platform that it becomes very hard for the authorities to pick up something. So many things may have been said in other shows, in other programs as well. But since this particular program of Samay Raina India's Got Latent is very famous, and Ranveer Allahawadia himself is very famous YouTuber, that is the reason why this controversy has picked up. But it's always not easy for enforcement agencies to pick up these issues. Evolving societal norms. What was obscene decades ago may not be obscene today. We have already seen this important thing. So, what is at the base of all this? Freedom of expression under Article 19. So, this is important for a prelims examination. There are 6 freedoms which are given. Speech and expression is the first one. Then you can, freedom of movement, you can make associations, you can have the profession and choose the profession of your choice. You can, come on the road and protest peacefully. All those freedoms are given which are very important. And one of the most important and the base and the core of everything is the freedom of speech and expression. Now this gets directly affected by such cases, but there has to be a balance which has to be struck between freedom of expression and obscenity. There has to be a balance which needs to be made. That is the reason why restrictions are also imposed on these freedom, but the restrictions has to be reasonable. It cannot be arbitrary. So let's read what is this. The right to freedom of speech and expression is not absolute. That is the reason why reasonable restrictions are also applied on these freedoms. So clause number 1 of Article 19 gives 6 freedom. A, B, C, D, E, like this. Clause number 2, clause number 3, clause number 4, clause number 5, they all are reasonable restrictions. I hope you have understood. Article 19 of the Constitution of India, which guarantees the rights, also provides for reasonable restrictions on various grounds, including of the decency and morality. Okay, so this is a reasonable ground that you are allowed to speak and express yourself, but your speech and expression must not forget the limits of decency and morality. Whatever you speak must not become immoral or away from decency. This means that free speech has to be balanced against the contemporary community standards of morality when it comes to penalizing obscene acts or content. So again, balance needs to be maintained in such cases. So this was the current affair class for today. Thank you very much for joining me. We will come in the next class with next topic. Till that time, thank you very much for listening. Bye bye and have a nice day. Jai Hind.